we turn this over to Susan Aronson, who will be moderating the next session. So,
thank you so much, Mike. Good morning, and it's so great to see all of you here. We have a fabulous panel now, and we're going to begin with Professor Joel Trachtman, who's going to look at the legal aspects of renegotiating leaving. So, Joel?
Thank you, Susan, and thank you, Michael and George Washington. It's a pleasure to discuss these issues, and I want to first say that one of the things that Michael said at the beginning resounded with me, and that is that the statutory structure that we have does have the assumption that the president is more liberal in trade than the Congress. And so for the lawyers, we need to have a little more imagination, I think, as we write statutes. My focus is on this rather technical issue, but an issue that you might say is important to the structure of the United States democracy, the way that we make policy, and that is the issue of how power is distributed under our Constitution and subsequently under our statutes between the president and the Congress, and also with the courts in making trade policy. And so this is a question of U.S. foreign relations law. But on withdrawal from treaties, the international law is rather simple. And that is that in the modern United States trade agreements, they all have the possibility for withdrawal on 6 months' notice. That's been a statutory requirement for fast track, and they all have successfully negotiated that. And so they have this provision in NAFTA and in the WTO and in all of the other modern ones. But they don't answer the question, who operates that withdrawal power? So within U.S. foreign relations law, we have to seek an answer to that question. And as you can imagine, given a president who is protectionist and perhaps a Congress that is less protectionist, that will have an important effect on what happens. So the issues are, first of all, is this something that is decided by the Constitution? Second, because it's not definitively decided by the Constitution, is there a statutory allocation that we can refer to that decides the matter? And I think it's important as we look at this, especially in the context of the NAFTA and the WTO, but really for all of these modern trade treaties, what is the relationship between termination of the treaty and termination of the implementing statute? Does that implementing statute, as some have suggested, become a zombie? But actually not a zombie because it loses life, or does it become a zombie that continues after the treaty is over? And then the last question that I want to address, maybe more briefly, is would a lawsuit in this area be successful? And that's a question of justiciability and whether this is a political question that the courts would say we're not going to address. And as I say, this is a question of the structure of the United States checks and balances and our deliberative democracy, how we make these decisions in a liberal way that brings together multiple constituencies, or whether this particular power has somehow been allocated to the president acting alone. So to begin with the Constitution, importantly, and this is distinct from treaties about defense of Taiwan or the ABM Treaty, this is an area that is constitutionally allocated to the Congress and implicitly allocated away from the president. This is commerce, and under the Commerce Clause of the Constitution and the Import-Export Clause, it's an area of congressional power. And this is why treaties that have been entered into in this area are congressional executive agreements. They could also have been treaty clause treaties. Those are both treaties under international law, but in the United States, we now have a practice, especially for trade treaties, of entering into these treaties as congressional executive agreements with the vote of a majority of the House and the Senate. And as you know, that's done under fast track, what we now call Trade Promotion Authority, signed by the president, negotiated by the president, because the president is the sole organ for negotiations, and then authorized by a vote of Congress. And these trade agreements could not come into effect under the Commerce Clause without the vote of Congress. So the question then is, what is the area of the executive power? And the focal point is on the vesting clause and the vesting clause thesis that says the executive power is vested in the president. And so we have to determine what is the scope of that power. It certainly includes negotiation and signing. But here, and it's really an interesting question, and it's a question that our statutes do not respond to with precision, or even mostly at all. Who has the power to operate these treaties, including termination, which is my subject, but also amendment, decision-making, waivers, and so on? So that's the question. And interestingly, and maybe for non-lawyers, even for lawyers, it's surprising, these constitutional issues in areas of uncertainty can be addressed by what we call historical gloss or acquiescence. So it's not necessarily true that we just look at the documents. We sometimes look at the practice. So the first question I want to address is, has there been statutory delegation to the president? And of course, where the president acts with statutory delegation from Congress, you've got the full power of the legislative apparatus, the legislative and executive apparatus, and unless it's unconstitutional, that should be determinative. It could be that where the Congress takes over some presidential power, that would be challenged as an unconstitutional usurpation by Congress. Or it could be challenged as an unconstitutional delegation of legislative authority by Congress, a violation of the obligation to present new treaties, new legislation to Congress. And this is very important right now, where one possibility is not the termination of, for example, NAFTA, but the amendment of NAFTA. And it's an interesting question. If there were some deal that could be done that would bring the jobs back and make America great again, would that be something that could be done without congressional approval? And our Constitution is silent on that, and our statutory delegations are also silent on that issue. But my main point is that with congressional approval, the president can clearly terminate any modern trade agreement. So let me focus on the Trade Act of 1974 just for a moment. It says, as I mentioned, that trade agreements have to contain withdrawal provisions. And now we're going to parse language just a bit. It says the president may at any time terminate proclamations, but it doesn't say he can terminate. These are the proclamations that set the tariffs. It doesn't say he can terminate the agreement or withdraw from the agreement. And indeed, another provision of the 1974 Act separates entry into the treaty from proclamation. So entry and presumably, termination are separate from proclamation. So we don't know from this that the president has the power to withdraw or terminate. The NAFTA Implementation Act says that the U.S. can bring actions under the agreement, and what that means to me is that the agreement is part of United States law. And so remember this question: can the president change something that is in the United States legal system as statutorily adopted law? And then Section 107 of the NAFTA Implementation Act actually amended the Canada-U.S. Free Trade Agreement Act to state that when the Canada-U.S. Free Trade Agreement ceases, then the statute would cease. So it linked the treaty to the statute, something that has not been done in the NAFTA or in the Uruguay Round Agreement implementation statutes. Lastly, on the NAFTA statute, the president is authorized to proclaim additional duties as he determines are necessary or appropriate to maintain the general level of reciprocity. Why do I mention this? Because it would be one route to backdoor termination by raising duties on some factual basis, which would be in the president's discretion, and then causing retaliation and perhaps termination. So that might be a way to cause termination. Then under the Uruguay Round Agreements Act, we have a specific reference to withdrawal of approval, not withdrawal from the treaty, not termination of the statute, but withdrawal of Congress's approval, which, remember, I said Congress's approval was necessary to enter into it. And under Section 125, there's a procedure for withdrawal of approval. And so the question from that is, was that meant to be exclusive as to withdrawal, even though it speaks of withdrawal of approval, not withdrawal from the treaty itself? And then it does have provisions for consultation with Congress on decisions, amendments, withdrawals, but not on termination or withdrawal from the WTO. And so you might say, why wouldn't, if the president had the power to do that, why would they not have said, you've got to consult with us first? So we can draw at least some inference from that perhaps the president didn't have the power. And maybe under Section 125, Congress was taking that power to terminate for itself. Then again, this is part of U.S. law. And while it's clear that, so I think it's important to say, again, that the president doesn't have the power to unilaterally repeal statutes. I don't think one can infer it from the power, if it exists, to withdraw from the treaty. And indeed, the president has the obligation to take care to faithfully execute United States laws, including these laws, as long as they're laws on the books. I'll note that other implementing statutes do say that termination of the trade agreement gives rise to termination of most parts of those statutes. We don't have that for the WTO or for NAFTA. So my conclusion on this issue of statutory authorization is Congress knows how to delegate authority to terminate agreements. It had this issue in mind with respect to the Canada-U.S. Free Trade Agreement when it wrote the NAFTA Implementation Act. In both of those implementation acts that I mentioned, Congress delegated proclamation authority, but specifically did not delegate termination authority as to the treaties themselves. And as I said, under Section 122 of the Uruguay Round Agreements Act, Congress delegated other decision-making authority to the president and retained under Section 125 a unique and exclusive way by which to withdraw approval, which, if it has any meaning, must mean that it's the way to withdraw the treaty itself or to withdraw from the treaty itself. So doesn't seem like there's statutory authority for the president to terminate these treaties, and indeed some undermining of an argument for implicit authority to terminate. So then the question is, well, does the president have sole executive authority to terminate these treaties? And this is what some have called the vesting clause thesis. And indeed, the president has the executive power, and we have to determine what that is. And it certainly includes the power to sign. And I think most of us would have said it includes the power to operate these treaties, to make most of the determinations, decision-making under these treaties, although it's a really interesting question, and one that perhaps Congress would want to be more attentive to in the future. How much control should we have over these types of changes? And indeed, the amendments issue seems like one that you would really want to be sure to address explicitly. But the president is the sole organ for diplomacy. That was said in 1936 in this iconic case. It was repeated 2 years ago in the Zivotofsky case. The president is the sole organ for diplomacy. And interestingly, and I won't go through the history, but there has been a change. In the early years of the Republic, it seems to have been accepted that Congress had a determinative role to play in withdrawal from treaties. Since the beginning of the 20th century, that power has been eroded. And there have been a number of cases, including in commercial treaties, where the president has withdrawn the United States on his own. But as you know, in the case of Taiwan in Goldwater versus Carter, and the case of the ABM Treaty in Bush versus Kucinich, we had this question: can the president terminate those treaties? And in both of those cases, well, I shouldn't say it so quickly. In the Goldwater versus Carter case, the plurality of the US Supreme Court said it was a political question. So that's the Supreme Court's only statement in recent history on this. And then a trial court, a district court in Bush versus Kucinich said it was a political question. What they mean by it being a political question is the courts are throwing up their hands and saying, we don't have enough specific law by which to decide this. It's a really hot question, and there are adequate remedies in the political process, so we're going to take our nose out of this fight. In 1987, the scholars and judges who write the restatement of foreign relations law under the American Law Institute said that the president has the power to terminate treaties. Despite the fact that there's no Supreme Court statement on this, this idea of acquiescence, of historical gloss, seemed to them to support this proposition. But they weren't really focusing on commerce treaties. And so we have some question in this area of exclusive congressional power. Would the president's authority really stand up? Is termination of a commerce treaty an executive power? But one thing that seems relatively clear is that even if you can withdraw from the treaty, you probably can't withdraw from these statutes. Those don't go away by themselves. So to conclude, commerce is constitutionally committed to the Congress. The president has the executive power. There's definitely an overlap here, and we need some way to sort this out. The easy way to do it is with the statutory authority, because the president can't enter into these treaties without statutory authority. So it would be nice if there were clear statements about termination. There might be, in the WTO treaty, under the Uruguay Round Agreements Act, there might be a restriction on the president's authority. Remember, that provision says there's only one way for Congress to withdraw its approval. It's hard to know exactly what was meant by that, and it wasn't really well written if the idea was that there's only one way to terminate the treaty or withdraw from the treaty. But generally, there's an argument that the executive has power to terminate treaties, but it might be reduced in connection with congressional executive agreements made with legislation, and it might be reduced in this area of exclusive congressional authority of commerce. But it definitely doesn't terminate statutes, except in those cases of the treaties like Colombia, Korea, Panama, and Peru, where it's specifically stated to do so. And then finally, if this became a fight, There's a significant question whether it would be a justiciable question or would be a political question that the courts declined to adjudicate. And then finally, and this would be perhaps advice to the new administration, working with Congress, you can do anything in this area. Thank you.